want to welcome everyone to this afternoon's meeting. Before we get started, I'd like to ask everyone to please bow your heads for a moment of silent reflection. And thank you. Before we get started, too, I want to just remind everyone that this is National Clean Energy Week, and that Governor McMaster also proclaimed that Clean Energy Week in South Carolina as well. So if you want to look up the details on that, it's lots of information out there. All right, Mr. Pratt.
Mr. Chairman, we follow our usual procedures. The next meeting will be next Wednesday, October the 7th at 2 p.m.
Wednesday the 7th at 2 p.m.
Yes, sir. Moving to our utility agenda. Our first two items are interconnection agreements. They can be taken together. The first item, number one, is docket number 2019-296C with Home Telephone Corporate, ALEC LLC, DBA Home Telecom, and Comcast Phone of South Carolina Incorporated. And item number two is docket number 2019-294C between United Telephone Company of the Carolinas, LLC, and CenturyLink and Teleax Incorporated.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I'll take the items together, and I would move, Mr. Chairman, that we approve the agreements, interconnection agreements in items 1 and 2 as identified by Mr. Pratt. So move, Mr. Chairman.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? Not all in favor, please say aye. Aye. All opposed, no. And the motion carries. Thank you.
Item number 3 involves docket number 2019-14C, 2013-239C, 2015-94C, 2015-368C, and involves designations of ETCs.
Mr. Chairman.
Commissioner Belser.
ORS has reported that all carriers who had not filed annual reports are now in compliance. Therefore, I move that the clerk's office cancel the hearing in this matter. That's my motion.
Thank you. You've heard Commissioner Belser's motion. Are there questions or comments? Not all in favor, please say aye. Aye. All opposed, no. And the motion carries. Thank you.
Chairman, item number 4 involves docket number 2016-29WS and Harbor Island Utilities.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, Harbor Island Utilities provides water and sewer service to customers on Harbor Island, South Carolina, and is requesting that the Commission clarify whether its territory for sewer service includes potential customers outside the gated community. The utility states that it is the only entity capable of providing sewer service to anyone on Harbor Island, and that it has adequate capacity for the businesses and residences along U.S. Highway 21. The utility further states it is only proposing that its wastewater system be available for those wishing to tie on, and that there is no requirement to use their facilities. An updated map has been provided. Fripp Island Public Service District does not oppose the clarification of the sewer service area. Fripp Island Public Service District currently possesses the right to provide water service to the businesses and residents located on Harbor Island along Highway 21, but since Harbor Island Utilities would provide only sewer services, there would be no conflict between the two providers. Mr. Chairman, I would note that ORS recommends approval. Therefore, Mr. Chairman, I move that we clarify that Harbor Island's utility sewer service areas includes parts of Harbor Island as delineated in the updated service maps provided on September 23, 2019. It is not restricted to the gated community. Those outside of the Harbor Island gated subdivision may, but will not be required to tie on to the Harbor Island utility sewer system if they wish to do so. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 5 and docket number 2019-189 WS involves a request for a waiver of hearing.
Mr. Chairman,
Commissioner Belzer.
Jacob Utilities is requesting that the hearing in this matter be waived. Although there are no interveners in this docket, I move that we hold that request in abeyance pending further investigation. South Carolina Code Annotated Section 58-5-720 provides in part that the Commission shall, before the granting of authority or consent to any water or sewer utility regulated by the Commission for the construction, operation, maintenance, expansion, or improvement of any facility or system, prescribe as a condition to the consent or approval that the utility shall file with the Commission a bond with sufficient surety. As mentioned in the last two orders concerning the Rosewood at Clemson development, this Commission is concerned about the company's current financial security in light of this proposed expansion. The company's sewer utility bond amount is already at the maximum amount allowed by statute and Commission regulations. However, the company's water utility bond amount is currently set at $275,000. Given Jacob's proposed expansion, I also move that we request ORS to review and investigate and report on the adequacy of the current water utility bond and whether an increase in the amount of the bond is warranted prior to consideration of approval of this proposed expansion. So move.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 6, we have docket numbers 2015-274W, 2016-126W, and 2018-28W, and they involve the request for approval of JCAB Utilities LLC's 30-day notice.
Mr. Chairman,
Commissioner Irvin.
JACABB Utilities states that its bulk water supplier, the City of Clemson, has increased its rates and seeks to pass the increased cost of its bulk water purchase to its customers. According to the utility, the new volume rate is $3.48 per 1,000 gallons, which is an increase of 0.07 cents per 1,000 gallons. And the new customer charge is $10.57 per month, which represents an increase of 21 cents per month. The utility states that a 30-day notice has been included in the customer's bills, communicating that the increase is to be effective October 2019. I move the adoption.
Thank you. You've heard Commissioner Irvin's motion. Are there questions or comments? If not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Chairman, in item 7, we have docket number 2019-64WS. We have a request for a night hearing.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we direct staff to schedule an evening public hearing in Beaufort County. So move.
Thank you. You heard Commissioner Whitfield's motion. Questions or comments? If not all in favor, please say aye. All opposed, no. Motion carries. Thank you.
Mr. Chairman?
Yes, ma'am.
I asked to be shown as present, not voting.
Okay. We will let the record show that you are present and not voting.
Chairman, item number 8, docket number 2019-185E, 2019-186E, we have a request for confidential treatment.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, the South Carolina Solar Business Alliance is requesting protective treatment of certain portions of Ed Burgess's testimony and the exhibits filed in this docket. The Solar Business Alliance states that the purpose of this request is to respect the confidentiality allegations that Duke has proposed. Mr. Chairman, I move that we approve this item.
Okay, you've heard Commissioner Hamilton's motion. Are there any questions or comments? Not all in favor, please say aye. Aye. All opposed, no. And the motion carries.
Chairman, items 9 and 10 involve docket number 2019-225E and 2019-224E, and they are both requests for confidential treatment.
Commissioner Urban.
I move that we grant these requests for confidential treatment of Duke Energy Progress and Duke Energy Carolinas in these dockets that have been identified by Mr. Pratt. The companies make this request stating that certain information contained in Table 2 of their respective 2019 IRP updates reflect DEP and DEC's anticipated future costs to procure additional energy and capacity, and is commercially sensitive and proprietary. Also, Duke maintains that public disclosure of this information would harm the company's ability to negotiate and procure cost-effective purchases and discourage potential bidders from participating in requests for proposals. The companies represent that if this information was publicly disclosed, potential suppliers would know the price against which they must bid, and rather than bidding the lowest price possible, they could simply bid a price low enough to beat the company's projections to the detriment of the customers. For these reasons, I move that we grant the request for confidential treatment.
Thank you. You've heard Commissioner Urban's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 11 is docket number 2011-158E. Once again, we have requests for confidential treatment.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we grant Duke Energy Corporation's request for confidential treatment of the 2019 amended financing plan. The company asserts that the plan contains market-sensitive, confidential, and proprietary information, the disclosure of which could impact Duke Energy's financing costs. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Chairman, on item number 12, we have docket number 2019-185E and 2019-186E again, and it's another request for confidential treatment.
Mr. Chairman.
Commissioner Urban.
In response to order number 2019-604, Duke Carolinas and Duke Progress have filed updated redacted public versions of Snyder DEC Exhibit 1 and Snyder DEP Exhibit 1 that narrows the confidentiality designations in the previously filed versions of these exhibits to ensure all information that is not commercially sensitive or proprietary is being filed publicly in these dockets. The companies submit that they have entered into non-disclosure agreements with all parties that have requested to enter into an NDA, and that the companies have provided the confidential versions of these exhibits to the representatives of the parties that have executed an NDA. I move that we grant confidential treatment of the unredacted exhibits to witness Snyder's testimony in these dockets. So moved.
Thank you. You've heard Commissioner Urban's motion. Are there questions or comments? If not, all in favor, please say aye. Aye. All opposed, no. And the motion carries.
Chairman, we'd like to request to carry over item number 13.
We will carry over item number 13.
Item number 14 is docket number 2019-320E. We have a motion to dismiss.
Mr. Chairman,
Commissioner Belser.
in docket number 2019-230-E, Mr. Enrique McMillan Jr., who I will hereafter refer to as the complainant, filed a complaint against Duke Energy Carolinas, requesting this commission find the utility's installation of smart meters to be an unlawful infringement on his personal privacy. Complainant asserts Duke should be treated as a state actor because state regulation authorizes Duke to be the exclusive provider of electric power in its service territory. He claims that permitting Duke to install smart meters without the express consent of each individual customer amounts to an unlawful state surveillance in violation of the Fourth Amendment. Complainant further states that Commission Regulation 103-321 essentially renders all smart meters unlawful because it requires that meters be read and bills rendered on a monthly basis, not less than 28 days nor more than 34 days. I move that we find both of these arguments to be without merit and that we grant Duke's motion to dismiss this complaint. First, Duke is not a state actor, and complainant has no constitutional right to privacy that is enforceable against Duke. In Jackson versus Metropolitan Edison Company, citation 419 U.S. 345, 1974, the Supreme Court of the United States rejected the argument now advanced by complainant. In that case, the court held that a Pennsylvania electric utility with exclusive right to provide power to its service territory was not a state actor. Second, Regulation 103-321 merely requires that meters shall be read and bills rendered monthly. The phrase, not less than 28 days nor more than 34 days, defines what constitutes a monthly basis. It does not prohibit collection of data on a more frequent basis. In total, Environmental Solutions Incorporated at 351 South Carolina Reporter 175, 568 Southeast 2nd, 365 in 2002. The Supreme Court of South Carolina reaffirmed its long-standing rule that great deference must be given to an agency's interpretation of regulations where it has particular expertise. Our interpretation stated above is the only reasonable reading of this regulation 103-321. Although complainant contends at page 2 of his brief opposing Duke's motion to dismiss that smart meters literally violate the regulation several times a minute, hundreds of times per hour, and thousands of times per day, I move that we decline to adopt complainant's interpretation, which would lead to the absurd result of banning all but electromechanical analog meters. Based on these legal cases, I move that we grant Duke's motion to dismiss. I do note that the complainant is not without remedy. If he wishes to opt out of the AMI meter, he may avail himself of rider MRM, which was approved by the Commission in Order Number 2016-791 and amended by Order Number 2019-429. Under that rider, the company would install a manually read meter. So move.
Thank you. You've heard Commissioner Belser's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Mr. Chairman, Commissioners, item number 15, we have dockets number 2019-184E, 2019-185E, 2019-186E, and we have a motion for admission pro hoc vici.
Mr. Chairman,
Commissioner Williams.
I move that we grant the motion for admission pro hoc vici of Lauren Joy Bowen, Esquire, filed on behalf of South Carolina Coastal Conservation League and Southern Alliance for Clean Energy. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. The motion carries.
Item number 16, we have docket numbers 2019-185E, and once again 2019-186E. We have another motion for admission pro hoc vici.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we grant the motion for admission pro hoc vici of Maya Dened Hutt, Esquire, filed on behalf of South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? Not all in favor, please say aye. Aye. All opposed, no. Motion carries. Thank you.
And item number 17, we have docket number 2018-401E, 2019-51E, and we have a request for approval of a confidential settlement agreement and mutual release.
Mr. Chairman,
Commissioner Belzer.
I move that the commission approve the confidential settlement agreement and mutual release between Dominion Energy South Carolina and Eastover Solar LLC and Beulah Solar LLC. So move.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? Not all in favor, please say aye. Aye. All opposed, no. And the motion carries.
Item number 18, we have docket number 2019-3E. We have a request for approval of annual review of base rates for fuel costs.
Mr. Chairman,
Commissioner Irvin.
I move that we adopt a resolution of the case that is in general agreement with the joint proposed order of Duke Energy Carolinas LLC, the Office of Regulatory Staff, and the South Carolina Energy Users Committee, and further move that a written order be issued before October 1, 2019. This resolution would be consistent with our statutes, and accordingly I move that we find Duke Energy Carolinas fuel purchasing practices and policies, plant operations, and fuel inventory management just, reasonable, and prudent. I further move that we find just, reasonable, and prudent the methodology for determining the environmental cost component of the fuel factor and the methodology for allocation and recovery of the capacity-related cost component of the fuel factor. Duke Energy Carolinas proposed fuel factors reflected in Witness McGee's rebuttal testimony and exhibits are likewise just, reasonable, and prudent. I further move that we find the terms set out in the stipulation are consistent with the standards for fuel review proceedings conducted pursuant to South Carolina Code Section 58-27-865, 2015 Code of Laws, and that the stipulation is just, reasonable, and supported by the substantial evidence in the record. Mr. Chairman, during the proceedings, we heard from the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy witness Lander. Mr. Lander argued that the company should, at a minimum, track its gas pipeline utilization at a more granular scale to see if there are opportunities to resell unused pipeline capacity. During the hearing, the company's witness, Mr. Phipps, testified that the company could track its gas pipeline utilization at a more granular scale to identify if these are opportunities to resell unused pipeline capacity. Therefore, in future fuel cases, I move that the company should have such available hourly and daily metered usage readily available for production. Additionally, I move that the Commission require the company to present evidence in its next fuel case regarding whether or not it can monetize the unused natural gas capacity on days when the system is not constrained. I firmly believe this inquiry is important because of the potential benefit to ratepayers from the sale of unused natural gas capacity. So moved.
Thank you. You've heard Commissioner Irvin's motion. Are there questions or comments? Commissioner Belzer.
Mr. Chairman, I agree with and support Commissioner Irvin's motion. As for the prospective requirement for the company to track its pipeline utilization for opportunities to monetize unused gas, I note that the fuel statute, as found in South Carolina Code Annotated 58-27-865, states in relevant part in subsection F that The Commission shall disallow recovery of any fuel cost that it finds without just cause to be the result of failure of the utility to make every reasonable effort to minimize fuel costs, or any decision of the utility resulting in unreasonable fuel costs, giving due regard to reliability of service, economical generation mix, generating experience of comparable facilities, and minimization of the total cost of providing service. Intervenors SACE and CCL have raised an issue in this proceeding concerning the utility monetizing unused gas capacity. In future proceedings, I believe it is important for this Commission to have access to the data so that we can make a reasoned determination on this issue under the fuel statute. We can only address whether monetization of pipeline utilization or monetization of unused gas is a reasonable effort to minimize fuel cost if we have the necessary data. If there is unused gas or unused capacity which can be monetized, that issue needs to be explored, and it can only be explored when the data is available and presented to this Commission. For those reasons, I'm in full support of Commissioner Irvin's motion.
Thank you. Any other questions or comments?
Mr. Chairman,
Mr. Williams?
I would like to also support Commissioner Irvin's motion, just for the simple fact that there's a opportunity or possibility to provide ratepayer benefit in the millions of dollars. It's just something that I believe just needs to be explored. Obviously, as Commissioner Belzer said, we don't know what we don't know. That's an age-old adage. We don't know what we don't know. But if there's an opportunity, and according to the company's witness, Mr. Phipps, there's an opportunity for the company to track that information to determine whether or not that excess or unused gas capacity could be monetized for ratepayers' benefit. So thank you for making the motion.
Thank you. Any other questions or comments?
Mr. Chairman,
Commissioner Whitfield?
I would also like to kind of follow up a little bit where Commissioner Williams and Commissioner Belzer were going. I believe I recall witness Phipps said he didn't have that information, of course, when he was on the stand, but he did up here on the stand acknowledge under oath that the company could track that information in the future, but that he didn't have it in this proceeding, and that going forward, if they're able to not him, I think he described other employees who could track that, provide that information to the ORS as they seek their data request in advance of the next fuel proceeding. So certainly we vetted some of that information, Judge Irvin, and it did come out, and the interveners have brought this to the forefront, and I'm going to support your motion. Thank you, Mr. Chairman.
Thank you. Any other questions or comments?
Mr. Chairman.
Yes, sir, Mr. Commissioner Hamilton.
Mr. Chairman, I wonder, are we aware of any other state that is following this method of we're discussing now?
Mr. Chairman, if I may, to Commissioner Hamilton, certainly I don't recall that coming out in the record of this case, Commissioner Hamilton, but I am aware through NARUC that other states do, when the opportune time is, and as long as it doesn't impact reliability, other states do sell from time to time their excess natural gas capacity.
Thank you, Mr. Whitfield. Thank you, Mr. Chairman.
Thank you. Any other comments, questions?
Mr. Chairman,
Mr. Williams.
I also think, if my memory serves me correctly, I believe someone testified in that hearing that Virginia requires utilities to report that information. I think the the Southern Alliance for Clean Energy witness brought that up. I think Mr. Landers, what's his name, referenced Virginia requiring that information. Commissioner Hamilton.
Okay, thank you. Any other questions or comments? Okay. Well then, if none, all in favor of Commissioner Irvin's motion, please say aye. All opposed, no. And the motion carries. Thank you.
In item number 19, we have a natural gas agreement for transportation service with Firm Gas Standby in docket number 2011-351G.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we approve the agreement for transportation service with Firm Gas Standby between Diversified Plastics Incorporated and Dominion Energy South Carolina. So move, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? If not, all in favor, please say aye. All opposed, no. And the motion carries.
Mr. Chairman, item number 20, Doc ND 2019-11E is a presentation. I'd like to suggest that that be held after the conclusion of the transportation agenda.
Okay, we'll come back to that.
And item number 21, we'd like to request that that be carried over.
Item 21 will be carried over.
Mr. Chairman, moving to the transportation agenda, our first 8 items are new applications, and these can be taken together if so desired. Item number 1 is docket 2019-299T, Kiowa Island Club Holdings, LLC, DBA Kiowa Island Club. Item number 2 is docket number 2019-300T, Vintage Cars for Hire, LLC. Item number 3 is docket number 2019-301, Pinda Tours, LLC. Item number 4 is docket number 2019-302T, the application of Lakeisha Johnson, DBA KNW Taxi Service. Item number 5 is docket number 2019-303T, Palmetto Medical Transportation, LLC, DBA Crescent Ambulance. Item number 6 is docket number 2019-304T, Janice Brockington. Item number 7 is docket number 2019-307T, Mecca Limousine, LLC. And item number 8 is docket number 2019-308T, and that's A Golden Rule, LLC.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move that we approve the new applications in items 1 through 8 as identified by Mr. Pratt. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? Not all in favor, please say aye. All opposed, no. Motion carries. Thank you.
Item number 9 is docket number 2019-216T, and this is Workhorse Moving and Storage, LLC.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we grant the application of Workhorse Moving and Storage, LLC for a Class E household goods certificate of public convenience and necessity. So move.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And motion carries. Thank you.
Item number 10 is docket number 2019-205T. We have a request for waiver of notice.
Mr. Chairman,
Commissioner Belzer.
the applicant Gamecock Moving is requesting that the commission waive the publication requirement on the grounds that adequate notice of the proposed amendments were provided by the commission's website through its document management system. The Office of Regulatory Staff does not oppose waiving notice. I therefore move that we grant the request to waive publication as expressly allowed by Commission Regulation 103-193, subsection 2. So move.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Chairman, Commissioners, in item number 11, we have docket number 2019-148T, request for an extension of time.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move we grant the request for extension of time for Tiffany Nelson doing business as Distinguished Limo Service for an extension of time until December the 15th, 2019 to comply with Commission rules and regulations. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? If not, all in favor, please say aye. All opposed, no. And the motion carries. Thank you.
In item number 12, we have docket number 2019-162T, a request for an extension of time.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we grant the request of Mom's Magic Minibus LLC for an extension of time until October 1st, 2019 to comply with commission rules and regulations. So moved, Mr. Chairman.
Thank you, Commissioner Williams. You've heard Commissioner Williams' motion on Mom's Magic Minibus. Are there any questions or comments? Not all in favor, please say aye. All opposed, no. And the motion carries.
Chairman, I think you'll enjoy this one too. Docket number 2019-175T. We have another request for an extension of time.
Mr. Chairman,
Mr. Urban.
I move that we grant the request for Fantasy Party Rides LLC for an extension of time until October 31, 2019 to comply with the commission rules and regulations. So moved.
Okay, you've heard Commissioner Urban's motion for Fantasy Party Rides. Are there any questions or comments? This is a good day for people transportation. If not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Mr. Chairman and Commissioners, items numbers 14 through 16 are requests for cancellation. I think they can be taken together. Docket number 2019-120T and item number 14 is for Ride on Time LLC. Item number 15 and docket numbers 2019-48T, 2019-270T is a request for Superior Senior Services LLC. And item number 16 in docket numbers 2017-380T, 2019-270T, 2019-271T is a request by Superior Senior Services to cancel.
Mr. Chairman.
Commissioner Hamilton.
Chairman, I'd move we grant the request to cancel certificates in items 14 through 16 as identified by Mr. Pratt. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? If not all in favor, please say aye. Aye. All opposed, no. And the motion carries. Thank you.
Item number 17, docket number 2010-260T, we have a request by Bauer Signature Services for reinstatement of their license.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we grant the request of Bowers Signature Services LLC for reinstatement of Class C certificate number 8347, subject to compliance with all applicable commission rules and regulations.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? If not all in favor, please say aye. Aye. All opposed, no. And the motion carries. Thank you.
Chairman and Commissioners, in item numbers 18, we have docket number 2018-190T and 2019-270T, which is AA Coastal Transportation of LLC to suspend.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we grant the request of AA Coastal Transportation of South Carolina LLC to suspend Class C Charter Certificate number 9357 until September 1, 2020. So moved.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? If not all in favor, please say aye. Aye. All opposed, no. And the motion carries.
Chairman, Commissioners, in item number 19, we have docket number 2017-114T and 2019-270T, which is a request of Lou Ellen Warren, DBA Luxury Limousine, to suspend their Class C license.
Mr. Chairman,
Mr. Irvin.
I move that we grant the request of Lou Ellen Warren, doing business as Luxury Limousine Transportation, to suspend their Class C Charter Certificate number 9255 until January 26, 2020. So moved.
Thank you. You've heard Commissioner Irvin's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And motion carries. Thank you.
Chairman, item numbers 20 and 21 are requests to withdraw applications, may be taken together. Item number 20 is docket number 2018-343T, Fusion Transport Services, LLC. Item number 21 is docket number 2019-173T, the application of Ivory Solutions, LLC.
Mr. Chairman,
Commissioner Williams.
I move that we grant the request to withdraw applications in items 20 and 21 as identified by Mr. Pratt. So move, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Questions or comments? Not all in favor, please say aye. All opposed, no. And the motion carries. Thank you.
Mr. Chairman, that concludes our transportation agenda. I'd like to now turn the program over to our chief clerk.
Good afternoon, Mr. Chairman.
Good afternoon, Ms. Boyd.
Norman Scarborough and I are ready to provide some highlights regarding a timeline we've created regarding tasks that are delineated in Act 62 of 2019. If it's okay with the chairman, we're going to work from the podium to my left.
Okay.
So, Mr. Chairman, what Mr. Scarborough and I are just going to do today is just go over at a very high level what we have on the timeline, and then there's just one section that we'd like for you to think about as you review this document. So what we started, of course, with the avoided cost dockets, and we have the timing, for example, opening those dockets, reminders about a decision that we need you to make regarding how often, how frequently that you're going to have those avoided cost hearings. We know it's at least every 24 months, but decisions about how frequently to have those. We've opened the community solar dockets. We've notified a couple of months ago the requirements for the utilities to file information regarding their existing community solar programs. We've opened dockets under that 5827-460D. If you recall, I had one interpretation regarding interconnection and timelines, and the advisory committee and other interested persons provided us their summary. So we open those dockets, don't necessarily know that we need them, but we've left them there. The voluntary renewable energy programs, those dockets have been opened. We filed documentation to the utilities regarding those, and utilities have filed their programs in those dockets, in addition to the community solar. So maybe put a pin mark on those two, because I think they might need your review regarding the filings in those. And we note on the next one that the word proceeding is used regarding the voluntary renewable energy programs in 584130. So that's something else for you to consider. We have our hearings scheduled for the avoided cost dockets beginning, one of the entities begins October 14th. The other two begin on October 21st. Now, this is where we wanted to draw your attention just for you to consider. So we started out on one part of up here, the 5827-460D. Well, there's another section, though, under 5827-460A. And here it is, Mr. Chairman and Commissioners. It says the Commission shall promulgate and periodically review standards for interconnection and parallel operation of generating facilities to an electrical utilities distribution and transmission system, where such interconnection is under the jurisdiction of the Commission. And there's some more language. Paragraph 2, though, says the Commission shall, within 6 months of the effective date of the amendments to this section, establish proceedings for the purpose of considering revisions to the standards promulgated pursuant to this section. So we've listed that. We have not yet opened dockets under that section. And as you can see, Mr. Scarborough and I have listed down here at the bottom after each paragraph, if we have a date that we want you to reference, would like for you to reference, and for this particular situation, we've referenced November 16th, but just wanted to get that on your radar. All right, moving on.
We can take that up next week.
Yes, sir.
Probably.
Yes, sir.
Okay.
Okay, so the decision regarding your avoided cost dockets is based on our calculations will be due no later than November 16th. Within that docket and within that section of the law, 584120, there's some other sections I'm sure you're familiar with. You have some more work to do, like the commitment to sell forms. There's language referencing purchase power agreements. So it's pretty detailed. Just draw your attention to that. Then we have the generic docket. That's in, and what we tried to do too was reference that part of the law so that you can quickly find it in Act 62. So this next section, which we think there's a deadline around January 1st, opening the generic docket for each utility to investigate costs and benefits of the current net energy metering program and establish a methodology for calculating the value of the energy. So we've opened that docket, 162, all right? Within the next one, within 180 days, there's another update that's due by the utilities around January 2020 regarding their community solar program. So we just listed those dockets there for you that have already been opened. Next, there are some regulations that we can write regarding the lease of renewable electric generation facilities. Listed that there. We don't know when you might want to accomplish that task. The integrated resource.
Is there a deadline or is?
I don't recall there being a deadline for that, Mr. Chairman. No, sir. The integrated resource plans are mentioned next. And I know that you recently had some oral arguments regarding that and if you want to, I think there's some positions as to whether or not you wanted to establish any other rules or guidelines prior to. So you have something that's pending on that right now, I think. But anyway, we listed the other language regarding some other deadlines as it relates to integrated resource plans. And we also list here the dockets that we open for our IOU electric utilities.
Act 62 also, if you'll recall, makes some changes from the past. You now, as you'll notice here, the commission shall issue a final order either approving, modifying, or denying the utilities IRP. So that's a little different from what's been happening in the past. So you will need to do one of those three things.
Okay, and then, Mr. Chairman, the next section relates to the Public Service Commission and the Office of Regulatory Staff initiating an independent study, and it includes input from interested parties to evaluate the integration of renewable energy and emerging energy technologies. And the word consultant is mentioned in that section. And so I just bring your attention to a docket that we've opened. We filed the notice of drafting. It's for rulemaking regarding the Public Service Commission's process to employ through contract or otherwise qualified independent third-party consultants or experts. So that's why that's listed there. And the next section states the commission may require from utilities updates regarding the implementation of the state's renewable energy policies. Next one. The commission is authorized to open a generic docket for creating programs for the competitive procurement of energy and capacity from renewable energy facilities. The next one, authorized to engage a qualified independent third party to submit a report regarding the avoided cost. And so I've listed the rulemaking there again and the docket number. Next, updating the value of energy produced by customer generators annually and the methodology for determining that value, which is supposed to be revisited every 5 years. Solar choice metering tariff is next for applications received after May 31st, 2021. Mr. Chairman, no deadline on that. Also wanted to bring your attention to 5827-465, and our notes there says, our notes say no deadline. However, we think there's some important language in here. For example, it states, General Assembly finds that there's critical need to protect customers from rising utility costs. For example, equip customers with the information and ability to manage their electric bills. A lot of provide opportunity for customer measures to reduce or manage electrical consumption from electrical utilities in a manner that contributes to reductions in utility peak electrical demand and other drivers of electrical utility cost. So just really wanted to draw your attention to that section. I think that perhaps could be used over a variety of your dockets. Just want to draw your attention to that language. And finally, 5833-110, which allows the commission to adopt rules for such evaluation of other generation options. The heading that was used for that section is mandatory demonstration before commencing construction of a major utility facility. And that's all we have, unless Mr. Silver has something else.
Great, thank you. I appreciate the timeline and the organization of this. That is well done. And
We've got it in chronological order, so we'll know what to do.
That helps us on everything. And it's good to see the dones in red so that we can continue to done some more. So
That's right.
all right, thank you. Okay, I think I may have misstated or something, something a little earlier on the date of the next meeting, and I do know that I was telling folks when I make a mistake, the three hardest things in the world to say was I was wrong, and I need help, and Worcestershire. The date of our next meeting is October the 2nd. I think I said 7th, and I think I messed up. So October the 2nd. So just want to make sure that's clear on everybody. Okay, have we got anything else? All right, we're going to have we've got an allowable ex parte. We'll take a short break because we have to reset and redo a few things, but then we will continue that in just a few moments. And from this meeting, we are adjourned.